Hi, Clint Coons here with Anderson Business Advisors, and I'm going to take a few minutes here to walk you through how to complete our real estate joint venture agreement. It's pretty straightforward if you've been doing it for a while, and I can appreciate the fact that if you're new to these types of documents, they can seem a bit confusing. And so I hope to demystify this agreement for you and explain to you some of the provisions you'll be completing as you walk through it. Now, just keep in mind, with real estate joint ventures, this agreement is set up for two parties, and you have Party A and Party B. Party A is going to be the person who is funding the deal. Party B is going to be the investor. So it's assumed with this joint venture agreement that Party A will be bringing money into the JV, and Party B, who is the investor, will be the one who will be handling the project itself. Now, it's important to note that when going into a joint venture agreement with an investor, you have to ensure that there are certain safeguards in place. And the reason why we put this joint venture agreement together for our clients is that many of the JV agreements that we've looked at, there are no safeguards for the funder. We'll just call them the lender or the gap funder. And they would enter into these agreements with an investor, and we would often bring up, well, what happens if the investor can't bring the project to completion? What happens if the investor walks off the job? What happens if the property doesn't sell? And people are often left without an answer as to what would occur in those situations. So what we attempted to do in putting together this joint venture agreement is answer those questions, provide some protections to the best extent as possible that we can in this type of an agreement. Now, that being said, obviously, if you've looked at any of my videos or you've been to our asset protection event, the best form of a joint venture agreement is always a well-drafted limited liability company. That is where you're going to have the most protection. But in those cases where an LLC is not an option for you because the investor is unwilling to enter into an LLC agreement with you, assuming you are the funder, or maybe you're on the other side and you're the investor and you don't want to enter into an LLC agreement with someone, then this is another option. Okay, you enter into a typical joint venture agreement that lays out the obligations of each party. So with that, let's get started. Now, the first box is pretty clear. What you're going to do is enter in the date. So let's assume that this one is going to be entered into in September 23rd, 2016. Now this is set up for two LLCs. It's assumed, or two businesses, that if you're Party A, that you're coming in, you're loaning money in as an LLC. If you haven't set one up and you're Party A and you're funding these agreements, you should have an LLC, because this type of agreement could be construed as a general partnership and you have liability exposure. So you definitely never want to enter into this form of agreement in your own name. You always want to limit your liability. If you need to change that, maybe you're not dealing with LLCs or business entities, and that one of the parties happens to be an individual, then you can modify the Word version of this agreement that is available on our Platinum website in the real estate forms section. So we'll just call this one, We'll go in here and we'll say the funder, we'll call this Funding LLC. Enter in the type, let's just say Wyoming Limited Liability Company, hereinafter referred to as Party A, and Investor LLC, a Texas Limited Liability Company. All right, so that's Party B. Now, as you can see in the recitals right down here, it says, whereas Party A agrees to provide capital for acquisition, repair, and rehab, or for certain real estate, whereas the agreement, they desire to find a joint venture, where Party B will be the one who is handling the actual rehab of the property. So right here we want to put in the property address. So the property address, we'll just come up with it, 732 Broadway, Tacoma, Washington, 98402. So that's going to be the address of the property that's going to be rehabbed. Now, you'll see we put in here a number of other recitals that Party B has provided Party A with an estimated budget. That's very important, of course. If you're entering into this type of an agreement where you're Party A and you're going to be doing some funding, you want to know how much you have, what the expected budget's going to be. And then you have in here Party B agrees to provide services to the following to this joint venture agreement. Now, the next recital says it's the intent of the property that the project will be completed by a certain date. So when you're filling out this agreement, you have to have some expectation of when you're going to complete the project. And I mean, if I was lending money to someone, I would want to know, is this going to be a 3-month project, a 6-month project? I mean, how long will my money be tied up? And on the flip side, if you're the person seeking money for this joint venture agreement, you need to let the lender know this because they're loaning money on projects and they want to be able to take that money, get it back, and then put it back out on a different project. So they're interested in how many times they can turn their money during the year. So you need to put in an expected time frame for this project. So let's assume that it's going to be 8 months. We'll put in 8 months here. Now we'll come down here to the agreement. It says, now therefore in consideration of the mutual promises, so forth, we're going to name this joint venture just so we have something to refer to. So let's say we're going to call this the Broadway JV. And I mean, by naming it somewhat associated with the property address, it will always allow you to refer back to it and know if you've entered into multiple JVs, which one you're dealing with. And then to market, build, alter, repair, lease, and otherwise deal with real property, particularly and only in the lands and premises known as, and again, put in the address here, 732 Broadway, Tacoma, Washington, 98402. Now, if you're wondering why we're putting the address in twice, okay, we put it in up here, and we put it in down here in the agreement. Well, everything above the agreement, these are referred to as recitals in a contract. And recitals do not have really any binding authority when it comes to entering into agreement with someone. They're just used as background information. So if you're interpreting a contract, you know to some extent what the intent of the parties were entering into this agreement. But they're not actually terms of the agreement. And people oftentimes make this mistake. They think that if they put any binding provisions up here in the recitals, that somehow that becomes part of the contract or the agreement, when in reality it's not. Everything after the word agreement is what the parties have actually agreed to. So that's why we put the address in again. So, I mean, these other clauses are pretty straightforward. It's a sole agreement. It's understood that, the ownership of the property, set forth on Exhibit A. You make sure you want to put your legal description on Exhibit A, that this is what we're talking about here and how it's going to be held. Refinancing. This is a question that comes up a lot, whether or not the investor can refinance the property or borrow money against it. Let's say in a particular situation that there's, you have a hard money lender or private money first, and then Party A is coming in as a gap funder, and maybe you're Party A, you're that gap funder. Then are you going to allow the investor to refi out the private lender? Are you going to allow investor to go out and obtain additional financing on the property? If you intend to allow this, then put in the amount of the money that they're entitled to go out and borrow against the property. So if we want to put in that they can borrow no more than 10% of the current fair market value or 20%, you'd want to specify that here. Or maybe it's 0, so you'd put in 0. Let's assume that you run into some unforeseen expenses. For example, the investor gets started in the project. We have private money. We have gap funding money, but we need a little extra money. Maybe you're going to allow then the joint venture, Party B, the investor, to go out and find some additional financing. So I might put in here 10%. So the Party B can actually go out and finance a property, but no more than 10% of the current fair market value can be further encumbered. And this protects you, especially in situations if you're a gap funder and you've loaned money and it's unsecured. Because many times what I've found in working with joint ventures, that the party who loans the money as a gap funder, for instance, they may not be able to take a second deed of trust against the property. Now, I'm a strong proponent of collateral. Whenever you loan money to a joint venture, you seek collateral. If you can't get it against the property, ask the investor to provide you other forms of collateral, protect your investment. Even pledge the LLC interest that the investor owns this property. So if you're loaning or you're entering into this joint venture and you're a gap funder, and you don't have collateral, you do not want someone, the investor, going out there and finding other financing and possibly encumbering the property. So that's why I put this provision in here for refinancing the property, to limit the investor as to how much additional financing they can obtain on the individual property itself that's being rehabbed. So the term of the agreement. How long is this going to go for? Now, you remember up above, we put in there 8 months. You could then put in there, again, how long we want the term to be. We can put in 8 months as what the expectation is for this agreement. So maybe we'll go back, we'll put in 8 there. Now, of course, you can read through here. It talks about when the agreement is terminated. Of course, it's going to be terminated when the property sells. If someone breaches, if somebody doesn't do what they say, they go into bankruptcy or liquidation, then those are going to terminate this agreement. And so these clauses are very self-explanatory, and they make sense. When you read through it, you'll get an idea of what the intent is behind it. Okay, now let's talk about the obligations of Party A, the person who is funding the joint venture. Okay, so read this clause right here. Upon execution and delivery of this agreement by the parties, Party A agrees to contribute into escrow with, now you're going to enter in the name of the escrow company here. Let's just call it Real Estate Escrow Services. The following amounts, okay? Because you don't want, ideally, when you're loaning into a joint venture or for a piece of property like this, you don't want to give the investor the money. You want to make sure that the money goes directly to escrow. So it is used to actually acquire the property and possibly, again, for the rehab work as well. So now you need to check which of these particular provisions you would like in your joint venture, which one will apply to this agreement. So again, reading this clause, upon execution and delivery of this agreement by the parties, Party A agrees to contribute into escrow with Real Estate Escrow Services the following amounts as selected and initialed by the parties. All right. So you could put in here, in this one, you put in within, say, 5 days of execution and delivery of this agreement by the parties, $50,000 for the acquisition of title to the property. So that assumes then that you're just putting in money to buy the property. Within 5 days, Party B, obtaining title of the property, $20,000 for the rehab, repair, and development. So in this case, if you're going to put in $50,000, let's just do this. Within 5 days of execution of this agreement by the parties, $50,000. All right. And then for the acquisition and title to the property. So this says you're going to contribute $50,000 in the escrow to buy the property. Then, of course, you want each party to initial this clause. And then within 20 days after title's been obtained, then you're going to contribute an additional amount of money. Now, this is going to be for the rehab work, because let's assume that if the investor came to you and happen to be Party A and they tell you, I need $50,000 to buy the property for gap funding, and I need another $20,000 to do the rehab work. Can you provide me a total of $70,000? Well, I just don't want to give $70,000 to escrow because we only need $50,000 to close. So I'm going to give $50,000 for closing, and then I'm going to provide the investor $20,000 for the rehab work. And then you'd come over here, it'd be $20,000 for the rehab, repair, and development. Again, we want to initial these. So by choosing these two and selecting those, that tells us that in this particular agreement, we've selected $50,000 for the acquisition, and we're providing $20,000 for the rehab work. Now, the third one states that if the property is encumbered by a mortgage or first deed of trust by an unrelated party acceptable to Party A within blank days, we'll say we put in here within 10 days of Party B obtaining title to the property, then we're also going to contribute some additional funds to cover the mortgage payment. So oftentimes, or not oftentimes, occasionally what you'll find is the investor also needs funds because the project's not generating any money. The investor needs funds to pay the interest on the first position private money note. So if they went out there and they got hard money or private money, and the payment is, let's say the interest on the money that they borrowed is $800 a month. Well, if we know the project's going to last 8 months, that's the expected time frame, then I'm going to need to contribute an additional $6,400 to Party B, and that money is to be allocated just to cover the interest payments on that first position loan. So if that's the case and you need money for that as well, because it's interest only then with the balloon payment on that private money note that's the first that is encumbered against the property, then of course you got to check this box as well. So again, let's say within 20 days of Party B obtained title of the property, $8,000. Let's just call it $8,000. $8,000 to cover 8 months of principal payments due said under the financing. So then again, you put initials. That. So now it tells us this when we look back at this clause. Total all in for Party A is going to be $78,000. That's what was agreed upon. And we've broken it out so we know how the money is being used. If this doesn't apply, then you do not check the box and you do not enter in any of this information. All right. Now, obligations of Party B. So what we did here is we listed out what the Party A's obligations are going to be to this joint venture, how much money Party A agrees to contribute. Now we want to talk about what Party B, the investor, is going to do with the property that is purchased. So, number one, if initialed by both parties, execute and deliver to Party A as beneficiary a second lien deed of trust covering the property, subordinate only to a first lien deed of trust. Now, what does this mean? This states that if the investor is providing Party A with a second that's going to be recorded against the property, then you would enter this in right here. So let's assume that Green Turtle LLC has the first position deed of trust on the property. That's the private money that the investor used, Party B used, and you're the gap funder. So we put in here that Green Turtle LLC. All right. So this states that when you loan money or you provide financing for this joint venture agreement, you're going to get back a second deed of trust against the property. So your funds are going to be secured. So the investor is offering up a second deed of trust. It's just saying that it's only subordinate to the first position lender, which is Green Turtle LLC. So then again, you initial, just like this. And now it's covered. In the off chance this is not provided, because as I stated earlier, many times in joint venture agreements, the Party A is not given a second deed of trust, well then of course you would not fill this information in right here, and you would just leave it blank, because it's only effective if initialed by both parties. All right, so you can read the rest of these. Let's go down here to profit, losses, and return of capital. Now this discusses here what happens to the money when the property is sold. So, we'll read the clause together. The net profits and return of capital of the joint venture shall be divided between the parties upon sale of the property as follows. First, the costs of sale paid out of escrow. So anything that comes up with the cost of the sale, commissions and whatnot, that's going to be paid out of escrow. Second, to the primary lien holder in the amount then owing thereon, which is not to exceed. So this is important here. You want to know how much is the primary lien holder, the private lender, how much did they loan against the property? So if that first position loan was $150,000, then we want to specify in here that it's not to exceed $150,000. So that's the most the primary lien holder can receive from this joint venture when the property is sold. Third, to the second lien holder, provided said lien holder is not party A, and the amount then owing thereon, which is not to exceed, let's say $20,000 or $30,000. So you'd only fill in this clause if there's a second lien holder in front of you if you're party A. So in this case, maybe you have private money, hard money, then gap funding on the deal. So then you'd want to put in the amount here if there's another lien holder on the property that stood in front of party A. If not, just leave it blank. The third amount is to party of A, and the amount then owing thereon is shown in paragraph 6. So what this states here is that party A, that is if you're party A, you're going to get back everything shown in paragraph 6. And if you look here, it's $78,000. So the next amount of money is going to go to you as party A if you're party A. Fourth to party A in the amount of contributions shown on Exhibit B. Now, Exhibit B is where we would list any additional funds party A has agreed to contribute. So let's say that you're involved in this joint venture and the investor came to party A and said, I need an additional $12,000 for unexpected water damage we found when we were rehabbing a back bedroom. Well, in that particular case, if party A agrees to contribute that additional $12,000, then we'd want to list it on Exhibit B. So when the property sells, party A gets back the first amount of money they put in, the $78,000. Then they're also going to receive back any amounts listed on Exhibit B. In my example, it'd be $12,000, so that would be paid back. So there would be a total of $90,000 paid back to party B. Now, or party A, excuse me. Fifth, to party B for actual rehab costs incurred by party B. So let's assume that the investor also puts money in, then provided that the investor can provide receipts or invoices for anything that investor paid, party B that is paid, then they're going to get reimbursed. So party A gets paid all their money back before investor gets any of his costs reimbursed to him, or the LLC in the case of this agreement. And then after that's been paid out, then you have blank percent to party A and blank percent to party B. So if it's a 50-50 deal, then you would just put 50%, 50% here. So now after everybody's been reimbursed, all their funds, then the profits are split 50-50 on whatever remains. So that's what you would put in for Clause 8. All right, so we'll go back through here. And again, read through all of these provisions. These are important provisions. They discuss the obligations of the various parties and when it comes to this joint venture agreement. Now, limitation on management. So one of the issues that comes up a lot is in a joint venture is, are we going to cede all control to the investor? Are we going to give party A any say in this joint venture agreement? Now, if we put together a budget, which we've already discussed up in the recitals, that party B is to provide party A budget of expenses. Now, if the budget does not come in as what we've expected, because we got in and we started working on the property and we realized, hey, we're going to go over budget on this, then you may want to put in a clause that limits the authority of party B to go beyond the budget without the approval of party A. So that's what this blank is down here. So let me just walk you through this clause, limitation of management. It says, notwithstanding any other provision of this agreement, to the contrary, legalese here, party B shall not have the authority without the approval of party A to sell, sign, refinance all or substantially all the joint venture's property. Okay, that makes sense, right? You don't want party B selling the property without the consent of party A. Do not do any act, which would materially alter or make it impossible to carry on the ordinary business of the joint venture. So that, you don't want them to possibly go out and demolish the property and decide to start over. I've seen that happen in joint venture agreements before, where Party B decided to raise the property, tore it down, bulldozed it, and then said, hey, I need more money. And Party A said, what are you talking about? I already gave you $400,000. I have no more money to put into this deal, and you just put us underwater. Execute, deliver any assignment for the benefit of creditors of the joint venture. So again, Party B cannot go out and encumber the property without the approval of Party A. Expend or obligate the joint venture to expend blank amount of dollars in excess of the repair budget as attached here to as Exhibit C. So another exhibit you're going to have to this joint venture is that budget that Party B prepared. So if we state that we don't want you to go beyond the budget. So if the budget for the project is $70,000, then you can't spend more than $8,000 above that budget without Party A's approval. Now, where would this come in? This would be if Party B wanted to use her own funds, because what could happen is, let's say assume that Party B wants to go into this joint venture and they decide, well, we talked about putting granite tile in the kitchen, but I think I'm going to upgrade it to just granite slab. And if I do slab in the kitchen, on the island, and heck, why not carry it throughout the house on all countertop surfaces? Now you've just taken and you've increased the budget by $8,000. That's important to Party A, even if Party B is paying the cost, because I entered into this agreement with an expectation that I'm going to receive money on the back end beyond what I put into it. And if Party B goes out there and spends a lot of money, what would occur when the property is sold is, first position lenders that are secured by the property get paid. Party A gets all the money they put into the deal back, and then Party B gets all the money they put into the deal back. And so at the end of the day, between all the money that Party B put in and the money that Party A put in and the first position lender, there may be no more profit. So there's nothing to split up. So we want to ensure that Party B just can't go out and suck up all the profit by increasing the value of the property, or by not increasing the value, by throwing in a lot more extra money to it. So there's nothing left over for me at the end, because I'm entering into this agreement, if I'm Party A, with an expectation of profit. And I don't want Party B sucking that all up with the extra costs that don't need to be expended. So that's why we have this provision in here, to limit how much Party B can really put into the project beyond what the budget is. And then you can read the rest of them here. Borrow or obligate the joint venture to borrow any amount of money. Borrow money from the joint venture, either directly or indirectly, so Party B can't take money out. Commingle funds. Confess a judgment. Admit any person to the joint venture. So I don't want to bring in other people to this joint venture. So these are some protections here that we have. Now, sale of the property. I think you should discuss this whenever you're into a joint venture, how the property is going to be sold, who's going to sell it. So if you're going to offer it for sale in the MLS and through a certain realtor, then you'd want to put that information in here. So let's say we're going to sell it through ABC First Real Estate of Tacoma, Washington. All right, so that's who we're going to allow to list this property on the MLS, and it's going to be listed within 7 days of completion. So you'd want to put that in there, who's going to be selling the property. And you come down here, and there's some other clauses. What I think is important to always put into a joint venture is what happens if the property's not selling. So let's say it goes on the market. It's a bad time to put it on the market. What do we list the sales price for? I mean, if the realtor comes, looks at the property, or you have an appraisal done, and it doesn't come in at exactly what you thought you were going to sell it for, because originally we'd anticipated selling the property for $600,000. That was going to be the ARV. But it turns out that because of market forces, we're not going to be able to get $600,000, or it's not the appropriate price with given comps in the area. So what would you want to do then? Well, I would specify in here that you have the ability to decrease the sales price or the offering price, but you want to put in how much. So at the outset, maybe we state that you can drop the sales price by no more than 8%. So if we agreed on the sales price to be $600,000, but it turns out there's problems there, then the parties or Party B, without the consent of Party A, can reduce the price by 8% and list it for that. So in this particular case, you'd be able to list it for $552,000 without having to get Party A's consent. Now, if you've listed it for sale and it's been out there and it hasn't sold, it's been 60 days, then maybe you want to do another drop. And so if you have another drop, maybe that's 5%. So again, what we're agreeing to is that the property can be reduced, the sales price can be reduced by the following percentages over time. If in 90 days it hasn't sold, then maybe you give another drop, so you don't have to come back to this of 5%. Now let's say in the event the property has not received an offer or sold or closed 120 days after the asking price, it can be reduced by a further percentage. Maybe we give it one more drop there, 5%. Again, if you don't want any of these, you don't have to put them in. You can put 0 there. So I've even threw in 165 days after the asking price should be reduced by another, if you want to, 5%. If you don't, just put 0 in that. By accident. Just put 0 here. So it can't be reduced any further than that. The thinking behind these multiple drops is that you have a mechanism in place to say if it's not selling, we're going to reduce the price. We're going to reduce the price. But ideally, of course, you don't want to reduce it below what you paid or how much money you have into it. So you have to factor that in. Now, the parties agreed that the lowest possible sales price to prevent losses to the lender or any party is to be, all right, this is your break-even price. So let's assume that my break-even price is going to be on this particular deal $490,000. All right, so you can't go below $490,000 on the property. All right, without both investor or Party A and Party B agreeing to drop it that low. So that's the break-even price. You can't go below that. So if that doesn't happen, then the property is going to turn around and we're going to possibly turn it into a rental and lease the property if we cannot sell it or we can't come to an agreement. You look again, there's other clauses in here that are important. Salaries, no party shall receive a salary for services rendered to the joint venture, blah, blah, blah. Important clauses that you need to have in a joint venture agreement. They provide protections for each party. Of course, you would want to read these, make sure you understand what they do for you. And then notices. So you again here, what you're going to do is put in the information, the Party A, Party B, their address, attention who. So if you have to send notice to someone, where you can reach the various parties. So that's what you would put in here. So I think we use Funding LLC. So Funding LLC, and maybe the address for it is 3225 McLeod Drive, Las Vegas. You got it. Down here, attention, Clint Coons. And you do the same thing for whoever, investor LLC, all that information gets completed. All right, you got to choose where the agreement shall be governed, under which law. Typically, you want to choose the state where the property is located is what most people do. So maybe here we'll choose Texas. But you're free to choose if you want any other state. If I live in, say, Washington State, and I'm entering into this agreement, I may want it to be in Washington because if I'm funding it, it's my money, and I have to bring an action against the investor. I don't want to have to travel to Texas, so I may put Washington in there and argue that that's where I want it to be. So jurisdiction lies in Washington when it comes to governing this agreement. Washington law will apply, and that's where we'll handle any controversies. So it's really up to you when are filling out this. It's a negotiation between the parties. Now, what happens again if the property doesn't sell and there's a deadlock? So we've dropped the price down, and now we were down at our break-even price of $490. What do we do? So, or there's just a deadlock as to what's going to happen with the property, because something else has come up. One party wants out. then you want this deadlock and dispute provision in here. So in the event Party B wishes to sell or develop the property, and Party A does not, then Party B shall pay Party A within 90 days of written notice X% of the then fair market value of the property. All right, so this is a situation where Party B is wanting to do something and Party A has decided, I don't want to deal with it anymore. So maybe you put in there that he has to pay him 20% of the fair market value of that property, and that then gets Party A out of the deal. In the event Party A wishes to take over, say Party B isn't performing and you want to get Party B out, then you could come down here and you could put in what Party B would be entitled to. So maybe Party B is going to be entitled to 30%. So Party A would have to pay Party B 30% of the property. So you have to be careful with these clauses here. Make sure you're putting in enough to cover what's owed and what your expectations are. But I'm sure you can foresee situations where things don't work out. And for whatever reason, someone can't get the job done, or a lender needs their money back and they want out so they can loan it on another deal. So these are things that you'd want to consider when you're completing this agreement and put in what those payouts would be. Recording this document. Now, this is something to consider. This document should be recorded in the county where the property is located. So if the property is located in Tarrant County, Texas, then I would record this document there. And this then puts the world on notice. You record it against the property, that there's a joint venture agreement on there. And so this ensures that if somebody did try to sell the property, Party B tried to sell the property without Party A's knowledge, then escrow will pick this up on title, and they'll know that they have to pay Party A, or at least contact Party A, to figure out what the heck is going on with this property and the agreement. Okay. So I come down here, put in the names of the parties again. You sign your title. So in my case, I'm a manager of Funding LLC. I think that was the name again that we used. So you put in Funding LLC. That would be my signature would go here. My name goes under the line, Clint Coons. And my title, of course, of this LLC is manager. And then I would sign on this line, the by line. And of course, Party B would do the same. Again, now if we're dealing with individuals and we don't have entities, then you wouldn't want to change these up, and you would just have, their name, and they would just sign above it. You wouldn't put anything up here. So it depends on who you're entering into the agreement with. Always get it notarized. Have your signature notarized to show that you were, in fact, the one that signed it. This is very important. I can't stress this enough, the importance of notarizing these documents. Here are the exhibits. So the Exhibit A would be the legal description of the property. Exhibit B are any funds that you're bringing into the deal. And then we had that Exhibit C as well. And I forget what we had for Exhibit C, but we discussed it already. Those would be exhibits that would be filled out as you go through here. So with that, I hope this tutorial has helped you in demystifying this joint venture agreement as far as how you would complete it. There aren't a lot of provisions in here that you have to fill in, but there are enough. More importantly, you need to read this this joint venture agreement and understand what it is you're signing. It's always a good idea, too, depending on the state in which you're trying to utilize this agreement, that you have it reviewed by a local attorney to make sure that there is nothing in here that is contrary to that particular state's laws that would maybe hold any of those provisions unenforceable or invalid. So I can't, again, stress the importance, can't stress enough the importance of having this also reviewed by local counsel to ensure that it will comport with all local, county, state laws. All right, with that, my name is Clint Coons with Anderson Business Advisors, and this was my walkthrough of our real estate joint venture agreement.